Hey everyone, Chase Elleby, Joel Williams with Williams Elleby, coming to you today to talk about when a company can be liable for the acts of their employees. So Joel, when we talk about this topic, I mean, there's a lot of business owners out there, a lot of big companies, and all these companies have employees. But what's one of the first things, or first, I guess, sort of causes of action we look to when we're talking about companies and employees?
Well, there's several, right? There's several different theories that plaintiffs' lawyers can hook the employer on for liability of the acts of the employee. But let's just start at the beginning of the employment relationship. So there is a theory called negligent hiring. And in at least in Georgia, a lot of this conversation is going to be very specific to the state of Georgia, so I'll just go ahead and warn you about that. But at least in Georgia, an employer can be liable for negligently hiring an employee if they knew or should have known about the employee's prior dangerous propensities, right? So what that means is, let's say, for example, you're an employer and you're getting ready to hire somebody that's going to be making deliveries, driving all over the road and delivering food, whatever, you know. If the employer knows that the employee is going to be driving and they don't do don't investigate the driving history of the employee. Right. Or they do investigate the driving history of the employee and they see, okay, well, Johnny's got 2 prior DUIs, at-fault wreck, and 3 speeding tickets. Right. And they still hire them and put them behind the wheel of a car and tell them, go out and drive all over the place and do these deliveries. Right. Well, when Johnny causes a wreck, well, then the employer can be independently liable for that negligent hiring of Johnny in this situation and allowing him to get behind the wheel and drive around.
Right, yeah. If Johnny has 3 DUIs and it's caused multiple wrecks, he can't be delivering pizzas, in the neighborhood. Yep. Because that could be a problem.
Yeah, and there's other examples too. It doesn't just have to be driving, right?
Right. I think, I can think of let's say like a summer camp, right? You hire a camp counselor who you don't do a background check, come to find out this camp counselor has a history of whatever it might be, say, they're a sex offender and you don't know it, and then they're working at this camp and something happens and you're going to be, on the hook for that as well.
Yeah.
So
and even if part of the key here, because we're going to talk about negligent entrustment in a minute, but with negligent hiring, it's knew or should have known. Right. So if you're going to if you have a situation where you're going to put a person around children and leave them to supervise these kids, and nobody's going to be supervising that adult, obviously anybody in their right mind would at least run a background check on that person to make sure that they're not a registered sex offender, that they don't have a violent past and that kind of thing. So in that situation, the camp should have known had they acted reasonably. Right. And then obviously if you do know it and then you put that adult in the position to harm a child, well, that's a whole nother ballgame.
Yeah, exactly. Right? Yeah, and that borders on punitive damage type stuff. But that's a video for another day. So,
that's right.
All right, so let's talk about, that's the hiring process. Now, what happens if during their employment you learn of something?
Yeah, so very similar. It's just, instead of negligent hiring, it's called negligent retention. The main difference is that it comes into play when the employer learned of the employee's dangerous propensities. So say you hire them, you got no clue they've got 5 prior DUIs, and then at some point during the employment you learn that they have an alcohol problem or a drug problem, or you learn about these prior DUIs and you continue to retain them, then it's almost a matter of semantics, because then you're negligent for retaining that employee as opposed to initially hiring them.
Right. And then also too, another example would be, say, while they're working for you, they get their first DUI. Okay, what do you do to try to fix that, reprimand them? Were they punished? Do you retain them? Do you keep them? And then if they get a second one or cause a wreck, then you can look back and say, okay, company, Johnny had a DUI while he was working for you. Why wasn't he terminated then? Or why weren't there any sort of safety measures or mechanisms put in place to prevent this from happening again?
Yeah.
Right.
Another situation where an employer can be liable independently for an employee's acts is negligent training. Right. So I think of examples where someone needs specialized training to engage in their job activity. For example, driving a tractor trailer, right? You don't just know how to drive a tractor trailer. There's additional training that comes into place in order to do that safely. Construction.
Right. I'd say most construction jobs, right? Crane operating, dump truck operating, all that type of stuff, I would think would fall under sort of, you need to have a specialized training.
Yeah.
Right.
Or manufacturing, or using specialized tools in a safe manner.
Providing those tools.
Yeah.
Right.
There's certain jobs where the employee needs specialized training in order to do their job well and to do it safely. And if they don't already have that training and know how to do it, then it's up to the employer to teach them how to do it. And you wouldn't just give, say you're a company that trains people on gun safety, right? You wouldn't just give someone off the street a weapon and say, go train these people how to use it. Like, they have to master it first and know how to do it before they can teach somebody else the rules of gun safety and how to safely do it. So if you just pulled somebody off the street and said, go teach Chase, who has no idea how to safely handle a firearm, how to do it, and then this person shoots Chase, well, you're negligent for not training that person properly. So negligent hiring, retention, training, and then I also mentioned earlier negligent entrustment.
Right.
So that's different than negligent hiring. So negligent entrustment can come into place where the employer entrusts the employee with something that can hurt somebody else. Sometimes it's a dangerous instrumentality. Think security company providing a violent, someone with a known violent history with a gun and saying, go out and patrol these apartments and provide security. Yeah. It's probably a bad idea, right? It comes into play with motor vehicle incidents where, say you've got an employer who knows, and entrustment, you actually have to have knowledge. You have to know. It's not should have known, it's known about the employee's dangerous propensities. But let's just say it's a situation where the employer gives the employee a company vehicle and they say you can use it whenever you want to. So if you want to go to vacation to the beach, you can take our vehicle, you can drive it to go grocery shopping or whatever. But the employer knows that the employee has a pattern of dangerous driving habits, and they just entrust the vehicle to them.
Right.
Well, the thing about that is that the employer can be liable even if the employee's not on the clock in that situation.
Right. Because they had the company vehicle that was provided by the company. So when we see negligent entrustment a lot, this is not necessarily the company component, but like when a parent lets a minor child drive a vehicle, 16, 17-year-old drive a vehicle, and they know that kid speeds a lot. Then he goes and causes a wreck for speeding. Same sort of concept of negligent entrustment. Yep. So another theory where you can sort of hook employees with their employers is the respondent superior, which is basically when you're acting on behalf of the company, you are acting for the company, right? So if you're driving on the job, driving is always the easiest example, but if John Smith's driving a tractor trailer for company ABC and causes a wreck, in his role as a driver for company ABC, the company's going to be liable for that wreck. Yeah. So.
And one significant difference there is that for respondent superior or agency principles to apply for that liability to float up to the employer, the employee actually has to be on the clock.
Right.
They can't be driving to work. They can't be driving home from work. They have to be on the clock.
Yeah, doing company business.
Yeah, that's exactly right. Mm-hmm. So that's probably the most common example of an employer being liable for the employee's conduct. But it's not necessarily a situation where you have to prove that the employer is negligent.
Correct.
Because the liability or the negligence of the employee flows up, whereas negligent hiring, negligent retention, negligent entrustment all involve situations where you have to show independent negligence on the part of the employer.
Correct.
And it's not just solely directly tied to the negligence of the employee.
Right.
The last thing, the last thing that I do want to mention is sometimes situations come up where it's an independent contractor or it's someone who's just temporarily working for a different company. In those situations, you default back to what we call the time, manner, and method test. And so in order to determine whether agency or respondent superior theories apply, we have to look at the extent that the employer controls the time that the employee was working, the methods about which they went about doing their job, the time, manner, and the manner. I skipped one, right? And the manner in which they do their job. So it really goes back to the extent of control of the employer. So let's say Chase has got a business and I've got a business, and I borrow one of Chase's employees to help me with this one particular task, right? So whether I'm liable if that person is negligent really turns on whether I was controlling the time, manner, and method upon which that person was doing their job.
Right.
If I was controlling the manner and method, but not the time that they had to show up, then that liability doesn't flow up directly to me.
Right, and it can get a little thick, this topic, but I think just sort of kind of break it down, because you always hear people say, well, I'm 1099, or I don't really work, I'm a contractor, right? And there's a lot of reasons why companies would rather have 1099 or contractors as opposed to employees. And if you don't have a distinction between the two, you can get in trouble for having a contractor who really is an employee. So when you hear of this time, manner, and method, it's really a way for us lawyers to say, okay, well, Joel might be working or doing a job for this company, and the company's trying to say he doesn't really work for him. We're gonna look and ask the company, okay, well, are there timesheets? Does Joel have to be at this job at this time doing this specific task? If those answers are yes, 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 then he's going to be an employee, and the liability, like Joel's saying, is going to attach to the company. If it's a situation where, say, like a sales job is a really good example. Say you have a distributor who sells apples. They could go to Joel and say, Joel, I've got apples to sell. You go sell those to whoever you want, whenever you want, however you want. And then if you get, you get a cut on that, then that's going to be a 1099. That's going to be a contractor, because I have zero control over who he goes to, who he speaks to, or how he sells, other than I'm the one providing the product that he's selling.
Yeah.
So,
yeah, and so I think we've covered most of it, but I'll sort of wrap it up with this, and because a lot of people may be asking, well, why does it matter, right? Why does it matter if the employer is responsible under negligent hiring theories, or if they're just responsible under agency theories? Well, in some sense it doesn't, because they're still on the hook, but in some sense it does, because if there really is extenuating circumstances where an employer hired, say the driving example, somebody with multiple DUIs, and then they get in a wreck because they went to lunch and got drunk and then drove away, we want the jury to know about those prior DUIs. And if we can't show negligence in the hiring process or the retention process, then it's not guaranteed that all those prior bad acts are coming in a trial. Right? So a lot of it has to do with what we can get into evidence at the trial of a case, so that the jury will actually get a full picture and full understanding of the situation that they're trying to make a decision about.
Yeah, and in allocating damages, right? A jury could say, we think, in Georgia we have apportionment. I know we've talked about apportionment before, but a jury could say, we think X amount of dollars are owed by the company for their negligence, and we think, Y amount of dollars are, go towards the actual bad actor who caused the negligence or caused the injury. So,
and we're not going to go into this right now, but that opens up a whole other can of worms about what insurance companies pay and what type of policies apply and all that kind of stuff. So I guess the grand scheme of things is that if you're in an incident where someone else is on the job, or they're operating a company vehicle at the time that they injure you, then there is viable options for the employer to be brought into the case and held accountable for the actions of their employee. If you're an employer, these are just a lot of things to think about when you're hiring or retaining people, or if you have knowledge that one of your employees has got a criminal history or has got a colored past. You may want to take that into consideration when deciding whether to keep them on board as an employee, or whether to limit what they do for your, like if somebody's got 5 DUIs, we're not saying like everybody has a past. Everybody's made decisions that they're not proud of. And we're not saying that those bad decisions should prevent somebody from ever having a job before, but if you have 5 DUIs, maybe putting somebody on the road's not the best idea.
Right.
Maybe let's put them in the office and have them working where people can see them and make sure that they're not drinking on the job and subjecting other people to danger. So you got anything else on employers?
No, I mean, it's a thick topic. I know we could talk about it a lot, but no, I think we've covered sort of, or hit the highlights rather, things to consider. So.
Yep. All right. Well, we hope this video has been helpful to you. If it has, we'd appreciate you giving us a thumbs up, subscribing to our channel. Otherwise, we will see you next week when we're going to talk about fear and how powerful of a motivator it can be in negotiations.